Liberty Counsel files a brief at the Alabama Supreme Court in defense of life. I'm Matt Staver, founder and chairman of Liberty Counsel. Joining me is Deryl Edwards, president of Liberty Counsel Action. Deryl, this case comes out of the state of Alabama, and it's at the state's highest court, at the Alabama Supreme Court. And it's a case in which there is a prosecution that's taking place with regards to injury or damage that has been done to unborn children in utero because the mothers were taking drugs and ultimately caused damage. At any rate, the prosecution is in effect, and so now it's before the Alabama Supreme Court. The issue before the Alabama Supreme Court is whether or not the unborn child should have any recognizable rights. Of course, you have on one side the Southern Poverty Law Center that says they should not have any rights, and you have the American Civil Liberties Union. Liberty Counsel filed a brief that doesn't take a position on how the case should ultimately come out, but it does take a position on the history of protecting unborn children, and that unborn children in Alabama and around the country should be afforded constitutional rights or rights as a living human being in utero.
Well, the question I have, with the Southern Poverty Law Center being part of this, I think we need to remind people their stand against groups such as Focus on the Family, such as yourself and others, and you might want to mention that to people, how they are coming out calling us hate groups. Yeah,
the Southern Poverty Law Center used to be an organization years ago that was involved in the civil rights movement, and they represented cases against the KKK for some of the actions that they did against African Americans. But they have shifted and become very radical over time, and they are very pro-homosexuality, very pro-abortion, and they are very much involved in working with this current administration, trying to present ideas that groups such as Focus on the Family, Family Research Council, Liberty Counsel, and others, and leaders, including myself, are part of a hate group. And they say that because of our position on homosexuality and same-sex marriage. It's unbelievable that this group would go to that extreme, urge that people ought to be taken off the airwaves, that they ought to be classified as hate groups, and committing essentially hate speech because of their views on morality that is shared by the majority of people.
And the interesting thing to most people, who, especially Christians, believe that this is the ultimate hate, abortion, taking a life while it's in the womb. And so this case is a protection of that. Where does it go from here? Is there an appeal from the Alabama Supreme Court? Does it go then to the federal system?
No, there shouldn't be an appeal here. And in fact, the Alabama Supreme Court recently gave a decision not long ago that was dealing with a wrongful death. And it was a suit against some medical doctors for the wrongful death of a child in utero. And the Alabama Supreme Court said that this mother could pursue a wrongful death claim on behalf of her child that died in the womb, even though it died before it was viable. In other words, died before it was capable of living independently outside of the womb. And in that particular case, that's a great decision from the Alabama Supreme Court, that viability doesn't make you human or not human, that you're human from the day of conception and that you are accorded rights from the moment of conception. So this particular case now is coming after that, when that one was just decided a couple of months ago. What we did in this particular brief, and you can find this brief on our website by going to lc.org. You can go to the press release, and in that press release on the Alabama Supreme Court filing, you can click on the actual brief. It is a fascinating read. It is not the legalese brief that you normally read with a lot of legalese issues that you're not going to understand. It is a historical overview of the law going all the way back to the Greeks, all the way through the Commonwealth of various early developments here, but even going through England and Blackstone and all the way through the early founding periods up to the present time. And historically, here's an example. We trace it from ancient Greece to the present day. Common law in England and the United States, with the support from the medical and legal professions, recognize that, quote, and this is a quote from the brief, life is the immediate gift of God, a right inherent in every individual, and it begins in contemplation of law as soon as the infant is able to stir in the mother's womb, close quote. Now, that was pretty common, that once you were able to detect that life was actually in the womb, as when you felt something, then that was afforded protection. Why? Because up until that time, you didn't know. We didn't have the technology that the woman was pregnant. But as soon as you find out that there is a living being in your womb, from ancient time, from ancient Greece through the common law of England, through the common law here in the United States, up through the statutory development of law, it was protected. And then once medical technology started to advance in the 1800s and 1900s, the statutory laws began to get more strict. Once the medical technology was able to detect life at earlier stages, even way back then in the 1800s and 1900s, the statutory laws took over from the common laws, and the statutes expressly protected unborn children at earlier and earlier times. We now know that from medical science that it is a human being from the moment of conception.
Yeah, what's interesting, I think, is we went through this period in the early 70s where liberalism took control, and they were able to define this in terms of selfish needs. And but what we see now since that time period, the advances in medical science actually become a throwback to those historical evidence that you have, the tradition that has been there, to reveal that, yes, it is a person from the moment of conception.
It really does show that, and that's the fascinating thing about this brief. So I would encourage anybody to go to the website lc.org and download the brief. It's a fascinating historical overview and legal overview. What we find is that we have, and this brief points it out as well, Alfred Kinsey comes out with his book, about the human male, Sexuality in Human Male, 1948, and then his 1953 book. And that begins to start to liberalize some of the law. In 1954, the American Law Institute started to change some of the law regarding human sexuality. And it was looked at as good and natural to have all kinds of sexual activity even early in life as a young, as young as 2 to 4 years old, and even younger than that. Unbelievable, but that's what the premise was of Kinsey. That began to then infiltrate some of the systems. But even when 73 comes along and Roe versus Wade is there, we didn't have abortion in all 9 months in any of the 50 states. The Supreme Court just simply overrode the laws of all 50 states, went far beyond anything in the world, anywhere, and recognized basically by judicial fiat said that there's a right to kill your unborn child from the moment of conception until the child is born. Since that time, though, the laws in all the other areas of law have gone exactly the opposite. In tort law, personal injury, for example, you see this trend where you have a majority moving towards protecting unborn children. If you injure a child in utero, you will pay damages for that. In criminal law, if you kill a child or hurt a child in utero, you could be criminally prosecuted for that. You could have a double homicide for the death of the mother as for the death of the child. In wills, trust, and estates law, if a child is in utero, whether it's viable or not, it has property rights in the disposition of a will if that person died and left property to afterborn children. So you appoint a guardian for that unborn child. It goes on and on and on. All those areas of law are protecting and recognizing the rights of the unborn child. Roe versus Wade is on an island by itself, and it is continually and persistently eroding by both law, logic, and medicine.
So do you think eventually, short of an Obama appointment of ultra-liberal judges, do you think eventually that the Supreme Court is starting to whittle away at Roe v. Wade?
I think not just the Supreme Court, but I think all the areas from law, logic. I think ultrasounds are doing that. That's why you see more of the current generation more pro-life than the older generation. I think everything is moving in one direction. Roe versus Wade has its days numbered. Go to Liberty Counsel's website, lc.org. You can download this brief and support Liberty Counsel as we advance life, liberty, and family. Without your prayers and your financial support, we wouldn't be able to file briefs like this or represent individuals to advance the sanctity of life, to defend the family, or to advance religious freedom. Go to Liberty Counsel's website and make an online credit card contribution right there on the website at lc.org, or call us at 1-800-671-1776. Also, go to the Liberty Counsel website, lc.org, and sign up right now for the Awakening 2012. That's April 20 and 21 in Orlando or Central Florida. April 20 and 21, Friday night and Saturday, The Awakening 2012. You can go there to the website right now, lc.org, and sign up for that exciting program this coming April.